Hello everybody, so welcome back to my English law channel. So I'm going to be looking at international law within the law of the United Kingdom right now. So this is particularly public international law, and this governs the relationship between different sovereign states. It's even disputable what a sovereign state is. Is the European Union a sovereign state, or does it comprise 27 sovereign states? Anyway. So there's also private international law, and that's about private relationships between businesses or individual businesses across national boundaries. Okay, companies doing business with each other in different countries. Anyway, so I'm not really talking about European law or the European Convention on Human Rights here. So public international law, some of that pertains to the United Nations or some of its organs. The United Nations was founded really it was founded in San Francisco just before the end of the Second World War. But the Allies in the Second World War, they sometimes called themselves the United Nations. So its charter says, we were trying to avoid war, which twice in our lifetime has caused untold devastation. So to promote peace and security and things like that, keeping a clean environment, poverty reduction and so forth, to uphold human rights, to act in furtherance of development. So the United Nations, it fashions laws as treaties, and these are made in writing, and there are lots of these human rights instruments: the Convention on the Rights of the Child, the United Nations Framework Convention on Climate Change, the Charter of the United Nations is one of them, and there are various documents on social and economic rights and so forth. So there are other sources of international law, customary law, and there's some general principles of international law. Some of these go back to the Vienna Convention in 1820, tidying up Europe after the Napoleonic Wars, and about diplomat rights under the Vienna Convention can't be jailed in another country, and so forth. So international law is not a source of law for English law as such, because England and Wales is a dualist system. So international laws are only part of the UK legal system if they're expressly incorporated therein. Ratification, that's when the Parliament agrees to the treaty, doesn't actually make it part of the domestic law unless an Act of Parliament is passed to say, yeah, this is part of our domestic law. So the European Convention on Human Rights became part of the UK law in 1998, despite having been in force since 1953. So there are international treaties that the United Kingdom has ratified, though not incorporated into domestic law, and so therefore they don't have directive effect as law. So treaties, they sometimes courts sometimes take these treaties into account, even if they haven't been incorporated into UK law, because it gives them some guidance, such as in interpreting a statute. So they do have some indirect sway on domestic law. France, by contrast, is a monist system. Once France ratifies a treaty, that is automatically and instantaneously part of French law, as per Article 55 of the French Constitution. Okay, so people can cite statutes when seeking to vindicate their rights in French courts. So we'll look briefly now at law reform. So you'll realise that law is made in different ways, and law can be reformed. And why do we need to reform the law? Well, public opinion changes, new things like the internet are invented. So judges can change legal rules, and these principles, they change piecemeal. So they can't constitutionally engage in sweeping reforms of the law. Only Parliament is supposed to do that, and they do so in a, in an untidy and irregular fashion. And it's because of political pressure or the media shining a spotlight on something. The various ad hoc committees which are established to examine different areas of law. There was the Woolf Review of the civil justice system, as in Lord Woolf, who was the Attorney General under Tony Blair. The Attorney General was like the government's barrister. In 1996 there was a Legate Review of Tribunals. So there's the Civil Justice Council, and that advises the Lord Chancellor and the judiciary on how they should update the civil justice system. Civil as opposed to criminal justice, civil justice as in family law, contract law, and so forth. The Civil Procedure Act 1997 partly came out of those proposals. Remember, the government is free to completely reject any of these recommendations, to implement them all, to implement some but not others. Okay. So the main responsibility for counselling on law reform is the Law Commission of England and Wales. So it was set up by statute by the Law Commissions Act in 1965. There's also a Scottish Law Commission. So this is the statutory purpose of the Law Commission. It shall be the duty of each of the commissions to take and keep under review all law which they are respectively concerned, and with a view to its systematic development and reform, including in particular the codification of such law, the elimination of anomalies, the repeal of obsolete and unnecessary enactments, the reduction of the number of separate enactments, and generally the simplification and modernisation of the law. Close quotation. So they're meant to do it in a non-partisan way. They make suggestions to Parliament, and Parliament has the right to accept or reject these suggestions. So they don't actually make the law themselves, the Law Commission. It's often uncontroversial what they're saying. So the Commission's purpose, therefore, is to try and keep the law usable, modern, logical, and so they recommend ways to improve it, to make it cost-effective, to streamline the system. So one of the things they do is try to remain independent of government and try to remain out of political rows. So it makes proposals every few years. Section 3 of the Act says every 3 or 4 years they've got to do this. They embark on law reform projects, and the government departments engage with them. So the 13th Programme of Law Reform was published in 2017, and they made a number of suggestions. A new framework for disposing of the dead, as in cremation, is that to be the default setting? Administrative review, self-driving vehicles, electronic signatures, are they to be accepted? Because technology has changed, which has necessitated updated legislation. A new way of dealing with employment disputes, so to modernise trust law for the United Kingdom, based on its new global trading status outside the EU. New laws about land registration and chance of repair liability. A new law on residential leasehold, making the immigration rules more comprehensible. Smart contracts, and also the issue of surrogacy, of an egg from one woman is inserted into another woman's womb who gives birth to that baby. What if the surrogate mother, who's carrying an egg not her own, decides to keep this baby? Is she allowed to do so or not? Sperm donors, egg donors, to deal with that, because we go back a century, this didn't exist. Even 50 years, it was very, very rare. So having to take into account situations which didn't arise before, and often there's no real analogy in previous case law. So the Commission, it looks into modern law and sees what it thinks are some of the deficiencies and debilities of the current system, and looks at legislation in other jurisdictions and says this will be a good model to follow. So a consultation paper is produced, and it proposes solutions, and interested bodies, they can chip in, they give their penny's worth. And then at the end of the law reform project, a report for suggesting these recommendations is submitted to the Lord Chancellor. So remember, the Commission's role is solely consultative. It cannot legislate. It's the government who can do so. So there's a protocol agreed between the Law Commission and the government in 2010. When the Commission has produced its final report, the government will then respond within a year, saying which, if any, of the proposals they intend to implement. So there was the Law Commission Act in 2009, and the Lord Chancellor is obliged to report to Parliament each year and say what headway has been made on the implementation of these reports. So that was because the government sometimes wasn't implementing things or being over tardy, so they mustn't tarry over much. So legislation arising from the Commission reports includes the Contracts and Rights of Third Parties Act 1999, the Land Registration Act 2002, some bits of the Criminal Justice and Courts Act 2005. So many of the reports just go no further. The government disagrees, or thinks they're impractical, or there's just not enough legislative time. So some people, they castigate the Law Commission, saying the trouble is it depends too heavily on Parliament implementing these things. Well, what would you rather have? Critarchy? Is the Commission to legislate? I don't want that. So many of these legislations are never, proposals for legislation never actually make it onto the statute book. So some proposals are enacted, but this can take a terribly long time, and perhaps society and the law have gone elsewhere since then. So in 2017, the Lord Chief Justice, Lord Thomas, with the very wry name of John Thomas, he made two observations. He said that amendments to the law are going to be consequent on Brexit, and this will oblige people to reform the law on a wide scale, bearing in mind that EU law is enmeshed with British national law. Further, that changes to society arising from digitization, from all these social media networks and so on, the internet, new notions of ownership, looser contracts, 0 hours contracts, ambivalent employment status and so on, and ambivalency regarding intellectual property rights, the indeterminacy of certain consumer rights is going to require extensive legislation. So the law commissions are found in other countries, for example, New Zealand, the Commonwealth of Australia, the Republic of India, the Special Administrative Region of Hong Kong, and so forth. That's enough from me. Toodaloo.